you say, Jim Smith, you're late and you don't treat our vets right. Jim, I'm sorry, you're fired. Get out of here.
Did President Trump's removal of the National Labor Relations Board and Merit Systems Protection Board officials blatantly violate the Constitution? Let's talk about that. Buckle up, this is a long one. Hi folks, Tony DeWitt again with another video on the law. Remember, I don't dispense legal advice here, and this is what we're talking about today. Again, I have no attempt to be political here. I'm trying to answer a question for somebody who said that basically he thought it was blatantly unconstitutional to remove federal employees because Congress had said that the president couldn't do that. I always smile when someone says that anything is either clearly or blatantly or whatever. Whenever you use adverbs like that, it turns off that part of my brain that pays attention to you, because almost never in the law is anything clear. If there was, you wouldn't need lawyers. I didn't design this system. I just worked in it, okay? The fact of the matter is, whether you assert that something is constitutional or unconstitutional, there are always arguments on both sides. That's because I know that nothing is ever really clear until the Supreme Court speaks on the matter, and even then, it can be as clear as mud. The claim here is that the president is acting in a blatantly unconstitutional and illegal manner by firing these folks. And indeed, that is exactly what the district court in the District of Columbia found. Now, keep in mind, these are the lowest, not the lowest, I guess they are the second lowest level of judge in the federal system. And although they have life tenure, they don't necessarily have all of the skills of an appellate judge or a Supreme Court judge. So the question is whether the DC court, when it made this ruling, was right. Now, my guess is that some legal analyst on some television show communicated the opinion of the district court that this was blatantly unlawful or blatantly illegal, whatever it was. And my commenter here probably, because of the way he believes, he probably adopted that as his very own. Well, if this guy says it's, unconstitutional, it must be. But even when somebody like Alan Dershowitz says something, I take it with a grain of salt, because there is not a person walking around on the face of this earth that does not have a political viewpoint, including me. I just try to keep it out of my content because, as Michael Jordan once observed when people asked him why he marketed to people that they didn't agree with, or said, Republicans buy shoes too. And so I try to remember that everybody buys content essentially from me. And so I try to be respectful of other people. I don't ever tell you how to think. I do, however, report on things like appellate opinions, and that's what I'm doing here. Now, there may still be some of you out there who believe that the media are unbiased. But let me put it this way. If someone claiming to be a legal analyst went on Fox News and said this was unconstitutional, how often do you think he'd be invited back? In fact, if you went and looked at their coverage recently, you'd find that majority of it supported President Trump, with the possible exception of Jessica Tarloff, and I think she's sort of like their token liberal on that network, and it's hard to find any kind of balance on that. Fair and balanced. It's hard to find any balance on Fox News. It's almost all on the right side. But on the same token, if somebody went over to MSNBC and said the president clearly had this authority and these removals were absolutely golden, do you think they'd be invited back? And of course, the answer in both cases is no. And the reason they want to be invited back is because it pays good money, it gives them lots of free press, and with respect to the lawyers, it nets them and their firm a lot of additional business. To see whether the president has this power, or at the very least, a legitimate claim to that power to discharge people, let's look first at the text of Article 2 of the Constitution. Here's what that article says in meaningful part. The executive power shall be vested in a president of the United States of America. He shall hold his office during the term for 4 years, together with the vice president chosen for the same term, and be elected as follows. And then it goes in to explain how the president's to be elected, and a lot of that's been modified since. And then later on, it also says, he shall take care that the laws be faithfully executed and shall commission all the officers of the United States. So, this is what they call the take care clause. The president has the responsibility to faithfully execute the laws of the United States. One could make the argument that by terminating these people, he was violating the laws and not faithfully executing them because the law passed by Congress said, hey, you can't do this. But the way the president and the administration are looking at that is that in order to take care to see that the laws are faithfully executed, he has to be able to control the individuals who are executing the laws. And so if he can't control those people, then his mission or his uh, grant of authority from the Constitution is meaningless. If only the president holds executive power, then how can there ever be independent federal agencies exercising executive power? There can't be, because there has to be political accountability. And here's the thing, the Constitution created 3 branches of government, not 4. The dispute here seems to center around a 1935 case from the Supreme Court called Humphrey's Executor. But context is everything, particularly since most of us were not alive in 1935 to know what was going on. So we have to rely on history. During the 1930s, President Franklin Roosevelt faced significant opposition from the U.S. Supreme Court, which struck down several key components of his New Deal programs as unconstitutional. In response, Roosevelt proposed the Judicial Procedures Reform Bill of 1937. That was commonly known as the Court Packing Plan. Now, that plan sought to expand the Supreme Court by allowing the president to appoint an additional justice for each sitting justice over the age of 70, up to a maximum of 6 new justices. Now, Article 3 doesn't set the number of Supreme Court justices. Congress sets the number of Supreme Court justices. Roosevelt justified the proposal by arguing that the court was overburdened and needed younger, more progressive justices to handle the caseload efficiently. Hey, you old guys, go retire. However, critics saw the plan as an attempt to undermine judicial independence and to manipulate the court in favor of his New Deal policies. The proposal faced strong bipartisan opposition in Congress, and it ultimately failed. Well, yeah, but not really. It didn't really fail. Turns out if you threaten a bunch of guys in black robes who only have power if you recognize it, you pretty soon get a different approach to the New Deal. And Roosevelt indirectly achieved his goal. After 1937, the Supreme Court became far more receptive to New Deal legislation, a shift often referred to as the switch in time that saved 9, as Justice Owen Roberts and others started voting to uphold key New Deal programs. Over time, Roosevelt was able to reshape the court through natural vacancies and eventually appointed 8 justices by the end of his 4th term. Now, the United States Supreme Court case we're talking about here is Humphrey's Executor versus the United States. It's a 1935 case. It addressed the president's power to remove officials from independent regulatory agencies. The court held that President Franklin D. Roosevelt's removal of William E. Humphrey, a commissioner of the Federal Trade Commission, was invalid because the FTC Act limited removal to specific causes like inefficiency, neglect of duty, or malfeasance. The ruling established that Congress could impose additional restrictions on the president's power to remove officials from quasi legislative and quasi judicial agencies, distinguishing those positions from purely executive officers. The decision established the principle of agency independence from executive control. It was one of the decisions that propelled Roosevelt to expand the court since he knew he could not impeach them. But did the decision really limit the president's power forever? And keep in mind, when they reached this decision in 1935, they were pushing back against Roosevelt. It was, in some respects, a political decision. So Even though we like to think that the Supreme Court is not political, it has always been political to some degree. But years go by and things change. This is the opinion of the DC Circuit and involves Gwen Wilcox, who was the National Labor Relations Board chair, and Kathy Harris, who was a member of the Merit Systems Protection Board. The trial court decided the issue adverse to the president and indicated the plaintiffs should be enjoined and returned to work. The government took an emergency appeal to the DC Circuit to obtain a stay of the order, and this is what the district court said, or DC Circuit said. Ordered that the emergency motions for stay be granted, separate concurring statements of Judge Walker and Judge Henderson, and a dissenting statement of Judge Millett are attached. Interestingly enough, the opinion does do a pretty good job of giving us some reasons why the president's use of this power may not be unconstitutional. Now, they hold that it isn't unconstitutional, but again, they are only deciding the issue of a stay. And the reason they're only doing that is because that's the only issue in front of them. But they're not really deciding that issue. What they're doing is they're essentially giving the district court a little rebuke here, and they're doing it via opinion. So, Circuit Judge Walker says in Article 2, the Constitution vests the executive power in the President of the United States, and it requires him to take care that the laws be faithfully executed in order to protect individual liberty. The framers created a president independent from the legislative branch, and that's important. It's a part of the separation of powers. To further safeguard liberty, the framers insisted upon accountability for the exercise of executive power and lodged full responsibility in the President of the United States. The President is elected by and accountable to the people. Executive branch agencies do not disrupt that design when they are accountable to the President. But consent of the governed is a sham if an administrative agency by design does not meaningfully answer for its policies to either of the elected branches. Let me step out here and deal with something. All of these agencies have an odd number of members so that the decisions can be made by majority vote. But if there are 3 from one party and 2 from the other, it is more likely than not that politics is going to play some role in that decision because different parties view different policies differently. And indeed, isn't that why Roosevelt tried to pack the Supreme Court? Because the court wasn't agreeing with him and he wanted it to. So the idea that independent agencies are truly independent when they have members that are split between the two parties, to me, doesn't make a lot of sense. I mean, it's a nice thought that people could, get together, have a kumbaya moment, and, perhaps come to a reasoned decision. But unfortunately, today anyway, that seems to be kind of a remote thing to have happen. At any rate, that's why the Supreme Court has said that Congress cannot restrict the president's removal authority over agencies that wield substantial executive power. And in that regard, they cite this case here called Sela Law LLC versus the Consumer Finance Protection Board. In that case, they said the removed official suffered no cognizable, irreparable harm during the pendency of the appeals, nor of the agencies where they previously worked until the president fired them. The people elected the president to enforce the nation's laws, and the stay serves that purpose by allowing the people's chosen officer to control the executive branch. So that's the short 411 on their opinion, but they go into a considerable amount of detail. The opinion itself is well researched and well documented, and it lays out a little bit of a different approach to how executive agencies should be helmed. And the reason it does that is because of the more recent case law out of the United States Supreme Court. In other words, to borrow a quotation from Rachel Ziegler, it's not 1937 anymore. One of the things I frequently criticize about sovereign citizens is how they go back to the 1800s to cite cases from when there weren't even automobiles about a right to travel without saying anything about driving. The right to travel and the privilege of driving are not one and the same thing. You can't use a case from 1890 to say that you have a right to drive without a license. But in some respects, that's exactly what the people here advocating for the NLRB and MSPB members are doing. They're going back to a Depression era case that is effectively inapplicable in this context. Let's see if we can understand why. So the court goes into the background and they say these boards are executive agencies, executive branch agencies. Their members can only be removed for cause. That's the way they're set up. The president informed Wilcox that the NLRB had not been operating in a manner consistent with the objectives of his administration. He cited several division decisions in that regard, and Wilcox was removed, so she sued for reinstatement. The district court granted summary judgment to Wilcox, declaring that she remained a member of the NLRB, permanently enjoining NLRB's chair and his subordinates from effectuating the president's removal. A similar chain of events occurred in the Harris case. The president removed Kathy Harris from the MSPB prior to her term in 2028. In defending the removals, the government doesn't argue that the president met statutory criteria for removing these guys. What the government said is it's unconstitutional. The whole statutory scheme is unconstitutional. It's an infringement on the president's Article 2 removal power, a position consistent with the president's recent executive order regarding independent agencies. And that's what this note down here says. The government also maintains that federal district courts lack the equitable power to reinstate an officer who's been removed by the president. But because that's not the issue that is presently before them, that's not what they decide. Then they take a tour through history and talk about the presidential removal power. Under the Articles of Confederation, the early republic experienced problems with weak executives, and it was powerless to respond to national emergencies like the 1786 Shays Rebellion. And as a result, they recognized that structural protections, most significantly separation of powers, were critical to preserving liberty. In other words, you had to have three separate branches of government: a legislative body to craft and write the laws, an executive body to actually administer the laws and enforce them, and a judicial body to settle disputes between citizens as well as between branches of the government. The federal government could avoid the gradual concentration of powers in the same department through this design. Drawing on well established political traditions, the framers divided Congress into two chambers, the House and Senate. Now, the framers divided the legislative power, but they unified the executive. There's only one president. The framers deemed an energetic executive was essential to the protection of the community against foreign attacks, the steady administration of laws, and the protection of property and the security of liberty. Ultimately, though, the framers insisted upon unity in the federal executive to ensure both vigor and accountability. The unity afforded the president decision, activity, secrecy, and dispatch, and it guards against a plural executive's tendency to conceal faults and destroy responsibility at the same time. The framers understood the risks posed by a strong executive, and their solution was to make the president the most democratic and politically accountable official in the government, subject to election by the entire nation once every 4 years. The resulting constitutional strategy is straightforward: divide the power everywhere except for the presidency, and render the president directly accountable to the people through regular elections. Against that backdrop, the Constitution assigns a lofty role to the president. It says, look, you get to discharge all the executive power, yet the president can't discharge his duties without the assistance of subordinates, and the vesting clause empowers the president to direct and control those officials. As James Madison said, if any power whatsoever is in the nature of executive, it is the power of appointing, overseeing, and controlling those who execute the laws. That includes the power to oversee executive officers through removal, because the Constitution provided no textual limits on that traditional executive power. It remained with the president. With that historical backdrop, we look at the historical practice. The understanding that the president holds unrestricted removal power became widely accepted during the first 60 years of the nation. Washington removed 20 officers, including tax collectors and military officers and surveyors. And subsequent presidents also dismissed lots of different people. John Adams removed Secretary Pickering. Secretary of War John Armstrong was removed by James Madison. Andrew Jackson removes Treasury Secretary William Duane. To be sure, some of these removals prompted minor opposition from Congress. For example, after Jackson removed Surveyor General Gideon Fitz, the Senate adopted a resolution requesting the president to communicate his reasons, and the president refused. Presidents in our nation's first 100 years faced similar half-hearted resolutions and responses to their exercise of the removal power, but nobody really went far enough to challenge it. One exceptional case was the impeachment of Andrew Johnson, President Lincoln's vice president, who became president on his death. He was impeached following his removal of the Secretary of War. The impeachment charged Johnson with violating the Tenure in Office Act, which required the Senate to consent to any removal of any officers. Much of Johnson's defense in his impeachment hinged on his view that the act was unconstitutional, a view the Supreme Court later endorsed in the Myers case in 1920. Myers declared the Tenure in Office Act invalid insofar as it attempted to prevent the president from removing executive officers who had been appointed by him and with the advice and consent of the Senate. A few decades later, another removal dispute arose when Grover Cleveland dismissed the U.S. attorney. The U.S. attorney took it to court and he lost. History demonstrates the founders understood the president had the inherent, inviolable, and unlimited authority to remove principal officers, exercising substantial executive authority, and the president has exercised that authority since the beginning of the republic. That's not to say that the court's removal power jurisdiction has always been consistent. Though the court in Myers reaffirmed the president's unilateral removal power, Humphrey's executor created an exception to that rule. It left future courts to decide when that exception might apply. So now the court is going to look at this Myers case. That's the first one that held the president could unilaterally remove officers. Frank Myers was the postmaster, and when he was removed by President Woodrow Wilson, he sued. Congress had passed a statute that required Senate approval before removal of the postmaster, and the president had indisputably not asked for permission. The question before the court was whether the Constitution permitted such a restriction on his power. The court came down on the president's side, and here's what it said. First, it stressed that the president's supervisory power over officers was crucial for protecting the separation of powers. Second, it considered that the Senate role in presidential appointments carried with it no corresponding role in removals. Third, the court observed the Congress's power to create officers did not carry a corresponding power to limit the president's removal power over them. Fourth, and finally, the court noted that the threat that Congress could, by limiting removal, thwart the executive in the exercise of his great powers and in the bearing of his great responsibility by fastening upon him men who might render his faithful execution of the law difficult or impossible. He had to have the power to remove them. The court specifically included within that authority the power to remove executive officers whose duties included that quasi-judicial character, though the court noted the president cannot properly influence or control the discharge of a judicial duty. He may still consider the decision after its rendition as a reason for removing the officer. The court then notes that Myers was a landmark decision. It's essential to the constitutional separation of powers, the president's ability to take care that the laws be faithfully executed. Then came Humphrey's executor. It reaffirmed the core of Myers that the president holds an illimitable power of removal. But in 6 quick pages, devoid of textual or historical precedent for the novel principle it set forth, Humphreys carved out an exception for agencies that wield no part of the executive power according to the court. That exception permitted Congress to insulate officers of that agency, the Federal Trade Commission, from at-will removal. The exception rested on the court's characterization of the FTC as an entity that exercised no part of the executive power and that in no way acted as an arm or an eye of the executive. The court viewed the agency as wholly disconnected from the executive department, an agency of the legislative and judicial departments. That's what it said it was. Suffice it to say that that view has changed. Confronted with the 1935 FTC's role in investigating and reporting violations of the law, responsibilities typically associated with the executive branch, the court insisted that the FTC did not wield executive power in the constitutional sense, even though it performed executive functions. It seems to be a distinction without a difference. To justify the distinction, it classified the agency's power as neither political nor executive, but predominantly quasi-judicial and quasitive legislative. In other words, they created a fourth branch of government unaccountable to the people. The Free Enterprise Fund court case involved a challenge to the Public Company Accounting Oversight Board's double-layer removal protections. its members were removable only for cause by the SEC commissioners, who were in turn removable only for cause by the president. Reversing a panel decision of the Circuit Court of District of Columbia, the Supreme Court rejected the board structure as a violation of the vesting clause and the take care clause and the constitutional separation of powers. This is a 2010 case, by the way. The multi layered removal protections rendered the president helpless to oversee the faithfulness of the officers who executed the law. So, where did Free Enterprise Fund leave Myers? It called Myers a landmark decision, reaffirmed Myers' principle that Article 2 conferred on the president the general administrative control of those executing the laws, including the removal power. And Humphreys? Well, the court declined to extend that decision to a new type of restriction. The next case that came along was Seal of Law. That's an even more recent case, a 2018 case from the Supreme Court, which dealt with the Consumer Finance Protection Bureau. That case presented another new situation, an independent agency, the Consumer Financial Protection Bureau, led by a single director and vested with significant executive power. As it had in Free Enterprise Fund, the Supreme Court repudiated the decision of the District Court and the D.C. Circuit, explaining that Myers was the rule and that Humphreys represented the outermost constitutional limits of permissible constitutional restrictions on the president's removal power. It declined to extend Humphrey to the novel agency structure at issue here. Further, the court fashioned a clear rule for Humphrey's exception. It applies only to multi-member expert agencies that do not wield substantial executive power. Once again, Sela confirmed that in cases falling in the field of doubt between Myers on one end and Humphrey on the other, Myers controlled. Another case came along, Collins versus Yellen, and applied Sela's holding to another agency led by a single top officer, the Federal Housing Finance Authority, and in doing so doubled down on its prior reasoning as it had been understood by some, including Justice Kagan, to have gone even further than Sela law in affirming the Myers default rule. And again, that's a 2021 decision by the Supreme Court. So this opinion goes on for quite a while. But at the end of the day, the court here decided that the NLRB was an executive agency, as was the MSPB, and that the administration was more likely to win than were the plaintiffs. In so deciding, they applied Myers, Sela Law, and Collins, the oldest removal case and the two most recent cases, to reach that result. That was the core reasoning of the principal opinion. However, the dissent was similarly vocal about its views of the law, saying, among other things, the two opinions voting to grant a stay rewrite controlling Supreme Court precedent and ignore binding rulings of this court, all in favor of putting this court in direct conflict with at least two other circuits. The stay order strips the National Labor Relations Board and the Merit Systems Protection Board of the quora that the district court's injunctions preserved, disabling agencies that Congress created and funded from acting as long as the president wants them out of commission. I cannot join a decision that uses a hurried and preliminary first look ruling by this court to announce a revolution in the law that the Supreme Court has expressly avoided, and to trap in legal limbo millions of employees and employers whom the law says must go through these boards for a resolution of their employment disputes. He then goes on to say, in addition, the government's efforts to deconstitutionalize those statutory protections are uniquely unlikely to succeed given the long tradition of removal limitations and their particular justifications. The opinion goes much further on both the conferring opinions as well as the dissent, but I can't drone on here forever. My point is that this opinion is, at the very least, one significant appellate court opinion that has agreed with the administration that the president has the legal power and the constitutional power to remove these officials. Whether that will remain the view, be reversed by an en banc decision later, or ultimately wind up at SCOTUS is another question entirely. But it's pretty clear that there is good authority for the administration's legal position, even if a lot of people don't necessarily agree with it. Now, my personal view is that no board, commission, or agency, in my view, should be unaccountable to the public. Suppose your local school board sets up a separate board to determine which kids get to go to the charter schools, and you provide that board with a set of criteria they have to use when evaluating applications. Then you make the members of the commission unremovable by the school board. Could they then exercise that power in an arbitrary and unaccountable way? Sure, they could. That's the problem with these independent agencies. They don't have effective oversight. Sure, Congress can call them in front of Congress and berate them for what they've done, and the president can speak out against them, but the only way you really affect policy is by removing the people who are instigating those policies. And that should be something that every president, Democrat, Republican, or independent, would want to have the ability to control the executive branch. Because right now, with a lot of these injunctions, you have the courts controlling the executive branch, and that is explicitly what the Constitution prohibits. That's just the way the law is, and that's the way the constitutional order was designed. Would I have designed it differently? I don't know. I haven't thought that deeply about it, but I can tell you this much: what we have has worked pretty well for the last 200 years. Now, let me disclose my bias. And I do this because I think you need to know this. I had a case with the NLRB probably 20 years ago now, and it almost destroyed my ability to believe in the concept of due process. Because for the employer, in this case, it was a small little hotel inside of Jefferson City, and the worker was one of those people that you have in every organization who can find a way to complain about anything and 16 different ways to not get a job done. She was terminated for bad behavior, but because she had arguably made some reference to everybody working together or something to that effect. I don't remember the exact details now. The NLRB came in, did an investigation, which basically meant they took the statements of all of the employees, and none of the employees really liked this woman. They they took her statement and they took our management statement, and then they determined that there was a reason to hold a trial because they believed that we had committed an unfair labor practice. And the thing that was so unfair about this is that we introduced evidence that completely disputed everything that she had put forward, everything. And the NLRB judge just ignored it. So once he writes his administrative opinion, you go to the NLRB nationally and you say, this opinion's bogus. Here's the reason why. I laid out everything in a very comprehensive brief, and the NLRB just rubber stamped the administrative law judge's opinion. So then I took it to the Eighth Circuit Court of Appeals, which normally is a fairly friendly court, but when it comes to ruling on behalf of government agencies, they tend to take the agency's side. And I don't believe they did a very principled look at this case, and eventually we lost. Now, fortunately, they only had to pay, I think, $12,000 in back pay, and the woman did not want to be rehired, which was a good thing because I'm not sure what they would have done with her if they had rehired her. They certainly couldn't have given her any kind of authority to do anything because she didn't have that to begin with. But it was such a kangaroo court, and the judge in that the ALJ in that case was so unfair. His rulings were hit or miss. They didn't conform to the normal rules of evidence. It was an absolute disaster. And as a result of that, I came away with the idea that the NLRB should probably be revamped pretty significantly. And the idea that its personnel and its directors are unremovable is something that really stuck in my craw. So that may have colored my analysis here. Not that I had any analysis whatsoever. I just pretty much told you what the opinion of the district court or the circuit court of the District of Columbia was. But that, I think you need to know that I do have that bias, and I wanted to be fair about that and put that in here. So thanks for watching. Catch me down at the beach again tomorrow. Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above, and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.